Hi, this is lecture 3 of IPC, and I am Lokesh Pathak with you. So, here, as we seen in the second lecture, and we committed that in the third lecture, we'll be covering one important topic, which is common intention and common object, which is a very important topic in IPC. In various exams, it is being asked. What is the difference between a common intention and common object? So, the very first similarity between these two terms is that these both acts are related to multiple persons. Like when the act is done by several persons, these two acts are one of those. So if you see in IPC where it is mentioned about these two, common intention finds its roots in section 34 of IPC, while the common object is described from section 141 to 145 and then again in 149 of IPC. So first we'll see what is a common intention. So common intention, section 34 IPC says that the criminal liability depends on the involvement in common intention and not on overt act committed in the consonance with the common intention. So here again, which is a basic rule of criminology, that the intention is given the more attention. So here section 34 of IPC, which is related to common intention, where the multiple persons are involved in the act, it says that the intention is important. The involvement of those persons having a common intention is important, and the overt act which is committed in consonance of that common intention is not important. And now we'll discuss some case laws, and we'll see that in some of the cases the mere attention was given to the intention only and act was not given any attention. So that is the importance of the intention in IPC as well as the matters of the crime. So here there is one famous case which is from India, and the cases which I am going to refer here are from Indian jurisdiction. So the important case is Ram Bilas Singh versus State of Bihar. In this case, the Supreme Court of India, it held that the criminal liability was arrived on the basis of presence in prior planning for commissioning of crime. That the person who was having the criminal liability based on the common intention, it was based on his presence in prior planning of commissioning of crime. It shows the prior meeting of minds and it confirms the common intention. So that was the finding of this case, which is Ram Bilas Singh versus State of Bihar from Indian jurisdiction. In this case, the Supreme Court also held that although indulging in overt act is not mandatory, but the involvement in the criminal intention is making the person offender as per section 34 of IPC. So there are other cases also. The prime cases from Indian jurisdiction, there is another case based on for common intention, which is Shyamal Ghosh versus State of West Bengal. I'm repeating it, Shyamal Ghosh versus State of West Bengal. In this case, the joint liability was discussed, and there was seen that there was a pre-oriented plan in this case. So the pre-oriented plan again shows the common intention, and the second thing in this case was seen was the acting in pursuance of that plan, although the second point here is not given the importance. So formally the elements of the common intention, that the intention must be respected instead of the respect to the overt act, this was formally given the form of elements of this clause in a famous case of Indian jurisdiction, which is Jai Bhagwan versus State of Haryana. So after the case of Jai Bhagwan versus State of Haryana, in which Supreme Court observed that to apply section 34, which is common intention, apart from the two or more accused, the accused should be more than two factors must be established. The first one was common intention, and the second was participation of accused. Now the second one remains redundant because it has no role, because in the same case Supreme Court decided that the common intention, if there is a common intention but no overt act, then the accused will be liable as per section 34 common intention. But if the participation of accused is there in crime but no common intention is there, there is no liability. It means apart from these, although two factors are tabulated or described, but it was same time it was established that only one factor remains in play, which is common intention, and the overt act has no importance. There is another important case from the state of Maharashtra, from Indian jurisdiction, which is Suresh Sakharam Nagre versus State of Maharashtra, where it was again established that in order to attract the section 34 of IPC, which is common intention, there must be a pre-arranged plan and the prior consent. And here again there was no importance was given to the overt act. Now the second important point is common object. So because we have to compare both of these, so for comparing that, we understood that what is a common intention, and we seen that section 34 of IPC says about the common intention. It gives the weightage to the intention, not the overt act. There is we have seen 4 cases supporting this. The first one was Ram Bilas Singh versus State of Bihar. All 4 are from Indian jurisdiction. Another important case was Shyamal Ghosh versus the State of West Bengal, where the pre-oriented plan was seen. Then the important case was Jai Bhagwan versus State of Haryana. After that, there were 2 factors determined by Supreme Court. The one was common intention and another was the participation of accused, but at the same time the weightage to the first factor was only given and the second was typically neglected. Then the fourth case was Suresh Sakharam Nagre versus State of Maharashtra, which says that the pre-arranged plan and prior consent is made and the criminal liability was determined based on that. Now another point is common object. In IPC, common object is always seen in relation with the unlawful assembly, because when there is an unlawful assembly which is comprised of 5 or more persons, the common object concept is very visibly seen. Otherwise, for the 2 persons, common object cannot be interpreted so much of legal fully, because common object definitely this can be seen when there are more persons. So if you see, common intention is generally applied on 2 or more persons, while when there is a question of common object, it applies to more than 5 persons as per Indian Penal Code. So when we talk about the common object, we have to see unlawful assembly. So now we'll see what is unlawful assembly, where it is described in IPC, what is its provisions, and what are the typical case law related to common object. So after that, we will compare common intention and common object. So common object is described in various sections in IPC. It starts with section 141, which says about the unlawful assembly. Then section 142, which says about the members of unlawful assembly. Then section 143, which talks about the punishment for the unlawful assembly. The punishment for unlawful assembly in section 143 is 6 months imprisonment or fine or both. While in section 144 it says that the unlawful assembly, if it is joined with weapons, then this punishment can goes to 2 years or fine or both. After that, there is section 149, which says, because we have established till now the relationship between common object or unlawful assembly. So it says, section 149 says that any incriminating act which is performed to accomplish common object of any unlawful assembly is punishable by law. And more elaborately, section 149 says that every member of the unlawful assembly is held liable for the acts of the unlawful assembly. If any of the member has not objected to any of the act and any one of them commits a crime, all persons will be equally liable. Now let's see the case law with that. There are typical cases from the Indian legislation which elaborates the concept of common object or unlawful assembly. One of such is Roy Fernandez versus State of Goa. The case of Roy Fernandez versus State of Goa, in this case, Supreme Court of India, it held that to determine a common object, the typical circumstances which can be studied are the incident, the details of the incident which took place, and conduct of the members who were involved in the unlawful assembly, and the weapons they use to accomplish the tasks or accomplish their targets of the unlawful assembly. So this case is one of the milestone cases, because in that the Supreme Court of India, the case which is Roy Fernandez versus State of Goa, in that Supreme Court of India, it determined that what common object is and how it can be inferred from a criminal incidence. It says that the incident, the first point is the incident details, second is the conduct of the members, and third is the nature of the weapon used. These all 3 can determine that what was a common object. There is another case from the state of Kerala, which is Ramachandran versus State of Kerala. In this is also a very deciding case, because in that there was a significant observation made, and it was held in that case that common object can form in a spur of the moment, and hence, unlike common intention, Here for the common object or the unlawful assembly, which is related to common object, any prior consent of meeting of minds is not needed. Means you can form within a fractions of second your opinion or your view or your confirmation with the matching the eye of the people. You can make your mind and you can make a common object and you can do a criminal act. So this case was very important because it was established in this that the common object can form in a spur of the moment, and unlike common intention, it is not needed that there must be a prior matching of minds or prior meeting of the minds or common intention should be there. Another important case from India's jurisdiction for common object is Waman versus the State of Maharashtra, where it was seen that there was unlawful assembly and one of the member of that assembly, he commits an act to achieve a common object. Mind it that there was the occurrence that only one member of that assembly committed the act to achieve a common object, but it was within the knowledge of all other members. So what will happen? All of them will be liable as per this because it was in accordance with section 149 of IPC. So with this case law, we have seen the various characteristics of common intention and common object, but typically our purpose was to see the difference between both of them. So if you see, there are only 2 points of difference between them. The first one is related to number of members. As I said, for a common intention mentioned in section 34 of IPC, 2 or more persons are needed to form a common intention, while for the common object, which is mentioned in terms of unlawful assembly, section 144 of IPC and onwards, 5 or more persons are required. So number of members for common intention, 2 or more, and number of members for common object, 5 or more. The another important difference is the pre-orientation of mind or prior meeting of minds or plan. So as we have seen that in common intention, it is essential that there must be a prior meeting of minds. That is why it is called common intention. While in common object, it is not needed because we have seen in the case of Ramachandran versus State of Kerala that the common object can form in the fractions of second, in the spur of the moment. There is no essential need of any prior meeting of minds in this. So this is all about common intention and common object. And in the 4th lecture of IPC, we will see what is punishment, what are the typical type of punishments in Indian legislation, what are the elements of those punishment, what is the interpretation from famous jurist. Then we will see the theories of punishment. There are various theories of punishments. We'll see and we'll discuss about that. Thank you.